Now, I'll make an apology as well, because again, through everything, we don't get money. We don't get paid for what we do, there's no money coming in. The government we've already spoke about this is in England, Wales of 800 million. The Commonwealth Court gets nothing.
How do the criminals get the money if you're the person that's there trying to like do good and you get nothing? It goes like that.
Well,
in the
they
system,
take it. Well, they take it
It's
because
like-
they have the authority.
Yeah,
Right,
we
well,
should
basically what we're
take
saying just now is, look, we've set up this just now, we set up a simple website, and it says for that reason to display information, nothing more than that. But as it's developed,
ask what the site is? You said free for what was the final site?
well, if you go, there's two names really to go to, so you can use either one, but realistically, the best thing to do is just commonlawcourt.com. That's it, commonlawcourt.com. Now, this is used for information purposes. It says we've done that, but when the site was set up, as you can see just now, it's developed over the last 15 months. With that being the case, we've stuck up additional pages. As the pages go up, we don't have a computer programmer, we don't have help, we don't have finances. So this has been done through a web provider and we've set it up. But it's actually developed. If we'd known 15, 16 months ago where it was going, we would have tackled it completely differently. The thing is, we didn't have funding, we've set it up. But the website exists, but it says, given the demand in what's happening just now, we are changing it. So it is being changed just now. It says now, I was told, hopefully last week I would have had it, I was hoping to have it by now. He said, we have actually someone, a computer programmer working on it. He said, but the point is, unfortunately, he says, like, unlike any other site you see, is this one runs about 12 different databases at the same time. He says, and it causes problems. He said, look, what you can do is great. You've got this structure, the whole thing, change it all, and basically just make it user-friendly. So the website's been done just now. I said, I don't think it's that far away. It's pretty well on, but we might have something about a week's time. But when it goes up, it'll be really good. So that is in place, and it will change things, and we will have the information to assist people. There'll be videos, there'll be training, there'll be how-to videos, there'll be notices pages, there'll be a video page, there'll be further instruction and manuals, everything will be there. So in relation to the public notice and everything else, if you're a public notice and you're convening a court, you can put it on the Commonwealth site. That's enough, I would do it. So if you get that on, after you've done that, what you then need to do is then send out court summonses. Now, if it's an individual you're attacking, or you're obviously taking to court, what you do is you send out a court summons. The court summons is a simple two-page document basically saying, look, in plain English, look, I'm taking a I'm convening a court, you've attacked me, you've caused me harm, loss or injury, or you've caused me this here, I've suffered, so therefore you're being summoned to attend the court. This is for crimes committed against me and the people of the UK. Because effectively, if someone commits an offence, although you are dealing with it from an individual perspective, so you take on a case, you're doing so on behalf of the people.
You're setting the precedent.
Because what you're doing is the individuals concerned, when their actions, when they're committing a crime, as they're doing what they're doing to cause harm, loss or injury, can be applicable to every man or woman. So therefore, if they're being summoned to appear to answer these crimes or criminal charges, they are being called by the people. This is a summon by the people. So the summons would be we the people represented by, and it would be an individual name who would present the case, and that's it. And then the jury would listen to the evidence, decide what you want to do, but it's always we the people. So you send out a summons to the individual. Now the summons is a two-page document basically saying, look, this is a venue, this is what you've done, you've got an opportunity to attend, it says there are criminal offences you have to answer for. That's it, simple, right? With the court summons, because this court process is slightly different and nobody knows about it, this is from the statutory system, there's two additional documents required. First of all, there's a 4-page document, and the 4-page document is literally a document saying, look, this is what the common law court is. Right now, the information regarding the common law court is basically saying, look, the people are convening the court to deal with crimes against the people, and for the following reasons, you've been summoned to attend. This venue's been, obviously, this venue's been selected for the hearing. This date, you have to attend to answer here. Now, in addition to that, with giving this court information, there's two other things that they can do. For example, when someone's summoned to attend, first of all, they can be given a chance to respond, right, in writing. Now, should they wish to put in a defence, which they can rely on, they can send a written affidavit in. There's no point in the state or any individual writing in and just giving a letter and say, here, accept this. What we've said is no, if it's a court of law and it's for the people and we have to understand exactly what happened, you have to submit an affidavit and you have to sign it and have it witnessed. So therefore they will be held liable for anything they've done and will be prosecuted accordingly. So basically they're testifying under oath that what they're saying is the truth and the whole truth, that's it. So if they do not provide an affidavit, it's not accepted, end of story. Right, so that's
If they
it.
don't,
No, they have to submit a written statement, the
what if
affidavit.
so if you don't, does it just not
Well,
go
I was going to say,
anywhere?
hold on a minute. They've got to do that. That's the first instance. The second one is we also give them an opportunity to try and resolve the dispute before going to court, right? Because we're friendly people, not awful. They say, so basically what we say is, right, okay, you've committed a crime against me, I'll take you to court, but at the end of the day, if you can resolve it, or sort out what you've done, or obviously repair the damage, I won't bother with the court. So if you want, he says, I'm prepared to obviously meet with you. So what we do is we give them the opportunity to have a pre-trial conference. Now this has to be instigated by the individual who's been summoned, so they would contact the plaintiff and say, look, you've summoned me to attend this hearing, not keen on going, look, can we get together? Now, only if the plaintiff wants to get together to sit and discuss the matter, will we have a meeting. If the plaintiff doesn't want to see them, you don't have to. You just go to court. If the plaintiff says, well, yeah, okay then, fine, I will see you, there's conditions attached. Each individual that appears, that'd be a plaintiff and defendant, they can appear with one witness each. Right, so you can appear, and again, if you're the plaintiff and you're lodging a case, I would suggest that you choose the venue that you want, which is public. You say, right, this is for the meeting, end of story. If you don't meet, we're not having it.
Oh, you can pick where you
Oh
have
yeah,
it.
pick that. So basically, says the individual says, right, this is where I'm meeting, that's it. If they don't want to meet you, there's no meeting. He says, if you don't want to meet them, you don't have to see them. But the point is, they are allowed, and yourself as well, are allowed to take a witness. Now, what we've also said is, if you go along there and you have this meeting, what you're allowed to do is anyone attending the meeting can record it for evidence, right? So you can do that, so that's not a problem, so you can do that. Now, as I said just now, when you do that, the third document you give them is a statement of claim. The statement of claim is basically a simple document, basically saying, look, I've suffered a loss, and literally a paragraph saying, look, you've committed fraud, you've stolen my child, you've basically done that, you've stolen my car, you've done taking council tax from me, you've done X, Y, or Z. This is what you put down for your statement of claim, a simple summary. Now, when you do that, that goes in, you sign off. So these three forms go to the individual. Now, the other point, this is, which we'll go back to just now, if you had actually, it says, given the paperwork out and says, look, I need this affidavit in, if you wish to respond, you give me an affidavit. If they do not give an affidavit, effectively, they have no defence. That's the end of the story, right? So basically, if you can prove that you've issued the court papers, they've been served properly, if they do not respond, basically what they're saying is we're not defending it. Now, if somebody doesn't defend allegations against them of a criminal nature, he says effectively they're guilty, right? So therefore, he says that's it. Now the point being is, we don't accept it being honourable and lawful. We don't just accept that. So what we do is say, oh, okay then, right, fine, okay, well they're not putting in, we're not putting in an affidavit, right? But they can have a pre-trial conference. But they don't want to do that either. So again, it's a bit suspicious. So what you do is you turn up with a jury trial. So when you turn up with the actual trial, you then look for the defendant. Now, the defendant can turn up. If the defendant turns up on the day, right, two things happen. First of all, they have no defence, so they shut up, right? Basically, if they want the defence, they have to put in a written affidavit, right? If they have not supplied that, they cannot present the defence to the court. They're now refused that right, right? If they refuse that right, they are allowed to stay in the trial, they may attend, and they can sit on their back sides, right? The point being is, when they sit there as part of the process, they're not allowed to speak at all, unless the jury asks a question of them. And if the jury wish them to clarify a point, the jury can ask certain questions. The individual can do nothing but answer questions, cannot offer a defence. So that's it. He says, but the point is, if they don't give an affidavit and they don't give or don't have a pre-trial conference, I would say very unlikely they'll turn up at the hearing. But if that's the case, what you then have is you should then have a guilty verdict. But again, you can't actually turn around and say, well, look, that's fair to do that because we're honourable people. You've got to do it properly. So again, you say, no, it's not quite right. He said, we'll change it slightly. So basically, they did take the affidavit. They were given the opportunity, they haven't used that. They haven't had the pre-trial conference, they haven't used that either, and they failed to turn up. Well, again, that's not great. Right, okay, what we need to do is the jury members have to look at the evidence before them. So the individual, the plaintiff, will go to the jury and say, look, this is my case, this is what's happened, here is some of the evidence, and then they put forward their presentation. So they actually present a statement of claim to the jury. If the jury then look at it, based on the fact that it hasn't been rebutted, there's no defence offered at all, they should actually then find them guilty. But I think the issue, more to the point, would be is, okay, yes, they're guilty, but what are we going to do about damages or sentence? It says, are we going to sentence him to a week in the Maldives? Are we going to sentence him to a week in jail? I said, do what you want. Basically, he says, this is what they do. But the thing is, before you can really pass sentence, you need to know what's happened in the crime. So basically, the plaintiff will present the information, will explain what happened to the jury members, and again, the jury members can ask questions to clarify. The jury members are not targeting a plaintiff and trying to crucify them or catch them out. The plaintiffs will be trying to establish what's happened in the case, so how they can make a relevant decision. If they're going to charge someone and hold someone guilty, it's not fair to do so with limited information. So they may say, well, okay, fine, I understand what they've done, but what about this? So once the plaintiff explains, that will give the jury member more information. They'll be armed with more information to make an acceptable and lawful decision. So this is how it works. So basically, that's the system there. So it's simple, the process is simple the way it works. Now, as I said, the initial paperwork with your notice, that goes up. You then send off 3 documents, your court summons, your court information, which explains the process, and your statement of claim. You then normally give them ideally 2 weeks to do so, after which you then convene the court. But when you convene the court, what we do is we then come in now. To get back to your question, sorry I haven't forgotten about you. When you come back to the actual day in question, and you're selecting jury members and court officers, the way that we actually work just now, because we're not dealing with thousands of people, we believe through past experience that the way to work this, we come to an acceptable format. We operate with 2 bailiffs, which is, we're not obviously, we're dealing with it as honourable people, peaceful people, a couple of bailiffs will do. Now the bailiffs basically are responsible to stand up, basically to sit there and basically monitor proceedings, to make sure that somebody's not causing a disturbance of the court, make sure that nobody's attacking the individuals taking part, and again, what would happen is that when the jury adjourn to deliberate, they actually go away to an area and basically the 2 bailiffs will go with them. If they have a separate room to go into, they'll go to the room, a bailiff will go inside the room with them to make sure they're not phoning people that are on mobile phones or the internet or something, so they stay in there and you have a bailiff outside the door. So if the jury have a problem during the deliberations, they say to the bailiff, look, we need some instruction or help. The bailiff will then speak to the one at the door who will then go away to get the relevant information. So that's your 2 bailiffs. You have 3 officers which we tend to use. This is probably the easiest ones, right? You have the court secretary. The court secretary basically deals with the paperwork. The paperwork is obviously, there's various forms to complete, as is which obviously you'll see things. When you convene a court, there's got to be a sheet with a list of jury members, right? So the list of the jury members confirming their name and basically contact details. You then have basically, this is a list of the jury members and the decision they gave at the hearing. So obviously that's to be recorded. There's, for the actual deliberation, there's a list here that is giving a full description of the jury verdict with an explanation and obviously various awards and what we made in crime. So basically the paperwork there for the findings. You then, in addition to have that, have oaths. Every individual has to give an oath and swear under an oath. Now whether you wish to affirm or swear an oath is fine. that everyone submits an oath. So you do that. Now all these people have to be kept as a record and signed off by the secretary. So they make sure that they're done dusted with. It says similarly, it says when they deal with that, it says the court sheriff will also sign some of the paperwork. The court sheriff will actually sign some of the documents the court orders to give it validity, and obviously that's held on record. But when we're speaking about the court sheriff just now, we're not actually saying a sheriff as in sheriffs in Scotland, which are equivalent to judges in England. We're not saying a judge either. We're using the term sheriff loosely, but what the sheriff basically means is that individual has a basic understanding of the principles of law and procedures, and they sit there to monitor the whole thing. So they will watch to make sure it's being done lawfully, and they'll just make sure that the procedures are okay. There's a simple guide list which we've got a sort of job description where we obviously speak to the people beforehand. He says, but the sheriff actually sits, the sheriff, judge, whatever you want to call them, they do not take any part in the decision, right? Basically, he says they're there just to enforce what happens on the day and to make it public. Now, apart from that, literally, he says they don't play any involvement. The thing about the common law court is what you have is that the decisions are made and it's only made by the jury members. That's it. They actually create the law, they set the law, and it's based on obviously what they decide to do. The last individual is probably the most important. It says he plays no part in the proceedings at all, as in the verdict of the jury in the case, is the adjudicator. The court adjudicator is probably, this is the main one, is the court adjudicator needs to know a little bit more, but literally what they do is they introduce the proceedings. They introduce the proceedings, they make sure that all the people are appointed, that they're doing what they should be doing and monitor the situation. So they keep an eye on it, they will introduce the plaintiff, they will make sure that the steps are followed, and then after the jury come back, they'll actually dismiss them, tell them what to do, the jury come back with the decision, and then they'll obviously confirm the jury decision for the public. So they do that. So the adjudicator is a sort of person,